A huge court ruling just hit California, and a lot of people are already getting the most important part completely wrong. This was a major open carry win in the Ninth Circuit, but if you assume that means you can strap up and walk outside today, you could still end up in serious legal trouble. Quick question before we continue. Are you subscribed? Because what I'm about to explain could stop you from making a mistake that cost you your freedom, your gun rights, and a whole lot of money. Hit that button right now because this channel is about keeping you informed before the trouble starts, not after. Here's what just happened. January 2nd, 2026, a three-judge panel of the Ninth Circuit ruled 2-1 in Baird versus Bonta. The court said California's ban on open carry in counties with more than 200,000 people violates the Second Amendment. That is a big deal because around 95% of Californians live in counties that size. So when people say this case is huge, they are not kidding. The man at the center of this case is Mark Baird. He is a law-abiding gun owner from Siskiyou County. He wanted to openly carry a firearm for self-defense. He challenged California's system because the state had basically split carry rights into two worlds. In big counties, open carry was banned. In smaller counties, there was a licensing system on paper, but that did not mean the average person could easily get a license in real life. Now, this is where it gets interesting. The Ninth Circuit did not say every part of California's carry law is gone. The court focused on the open carry ban in the larger counties. The judges said open carry has deep roots in American history, and California failed to show a strong historical tradition that would justify banning it in most of the state. That matters because after the Supreme Court's Bruin decision, courts are supposed to judge gun laws by looking at the text of the Second Amendment and the nation's history, not by asking whether judges think the law sounds smart or useful. Let me break that down in plain English. The court basically said this: if the government wants to block a type of gun carry that falls under the right to bear arms, the government has to point to similar laws from early American history. California tried to do that. The panel said the state failed, and that is why this turned into a real win for gun owners. But here's the crazy part. A lot of headlines made it sound like open carry was instantly legal across California. That is not what happened. And this is the mistake you do not want to make. Just because a panel rules your way does not mean the law changes that same afternoon. Courts have process, appeals exist, mandates matter, timing matters. And if you move before the law actually changes, you could become the test case nobody wants to be. So, the first big takeaway is simple. Yes, this was a major constitutional win. No, it was not an instant green light to openly carry everywhere in California. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when police ask about your gun. Subscribe so you don't miss it because knowing the rule is good. But knowing how to handle the moment is even better. Now let's talk about why this ruling shocked so many people. Most people think courts only protect concealed carry permits now because that is where so much of the gun law fight has been. But this case said something very important. The right to bear arms is not only concealed carry. The Ninth Circuit panel said open carry itself is part of our history and tradition. That point is huge. For years, many states and courts treated concealed carry like the acceptable form of carry, while open carry was treated like some strange extra privilege. But the majority in this case pushed back hard on that idea. The opinion explained that historically, open carry was often treated as the normal and lawful way to carry, while concealed carry was the thing that got restricted more often. That flips the modern assumption on its head. Here's what most people get wrong. They think if a state lets you apply for a concealed carry permit, then the state can ban open carry and call it even. The majority rejected that logic. The judges basically said open and concealed carry are not the same thing for constitutional purposes. A state cannot just ban one mode and say, relax, you still have the other one, if history does not support that swap, and that matters in the real world. Imagine you live in a large California county. You are law-abiding, you pass background checks. You want a visible holstered firearm for self-defense. Maybe you believe open carry is safer because everyone can see you're armed. Maybe you simply do not want the legal traps that can come with concealment mistakes. Under California's older system, your option was basically blocked. This ruling says that kind of broad ban runs into serious constitutional trouble. But wait, there's something even more important. The case also exposed how messy California's so-called rural option really was. In smaller counties, open carry licenses technically existed, but one judge pointed out that the state admitted it had no record of even one open carry license being issued. Think about that for a second. A right on paper is not much of a right if nobody can actually use it. That is one reason this case has so many gun owners fired up. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. And let me give you a hypothetical example to explain this. Let's say a viewer hears about this ruling and thinks, great, I live in Los Angeles County, so I can openly carry tomorrow. He puts a holstered handgun on his belt, walks to a gas station, gets stopped by police. If he says, but the Ninth Circuit struck the ban down, that may not save him at all. Why? Because the ruling still had procedural steps left, and California's own Department of Justice warned law enforcement that the open carry laws remained in effect until the court process moved further along. That is why your second big takeaway is this. A legal victory and a legal change on the street are not always the same day. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first before the rumors spread and before bad advice gets somebody arrested. Click subscribe right now. Now, let's get to the part nobody is talking about enough. What happened after the ruling? Just a few days later, California's Department of Justice put out a bulletin telling law enforcement that the state's open carry restrictions still remained in effect for the time being. The reason was simple. The Ninth Circuit opinion had not yet taken effect. The court's mandate had not issued. And before that happened, the state said it would ask for rehearing en banc. If that sounds technical, let me simplify it. A three-judge panel is not always the final stop. In the Ninth Circuit, the losing side can ask a larger group of judges to rehear the case. California Attorney General Rob Bonta did exactly that. He said the ruling was deeply wrong and pushed for the court to rehear it. So, even though the panel decision was a real win, the fight was not over. This is the part that shocked me because it shows how fast internet rumors can outrun reality. The second the opinion came out, some people acted like California's carry map had changed overnight. But the state was telling police the exact opposite. Keep enforcing the current laws unless and until the court process says otherwise. That is why you cannot build your personal legal strategy off a headline, a meme, or a 10-second clip on social media. Here's a simple rule you should remember. When a court ruling drops, ask 3 questions. First, what exactly did the court strike down? Second, did the ruling take effect yet? Third, is there an appeal or rehearing coming? If you do not know those 3 answers, you do not know enough to act. And there is another reason this case matters beyond California. The Ninth Circuit's reasoning does not stay trapped inside one state's border. Other courts are watching. Other lawmakers are watching. Gun rights groups are watching. Gun control groups are watching too. The core issue is bigger than one county rule. The issue is whether states can wipe out open carry just because they prefer concealed carry. Now, this is where it gets even more interesting. There is already tension between this ruling and how another federal appeals court handled a similar issue. That means this question could keep moving up the legal ladder. And when federal courts disagree on a constitutional issue, that is the kind of thing that can pull the Supreme Court in later. So, your third big takeaway is this. Baird versus Bonta is not just about one California rule. It is part of the national fight over what bear arms really means. This information could literally expire the moment the next court order drops. Subscribe now, because the next video explains exactly what you need to watch for before any so-called carry win becomes real on the ground. Laws change fast, and if you wait until after the change hits, you're already behind. Let me close this out with the part that matters most to you. If you are a California gun owner, do not hear this ruling and assume all restrictions are dead. They are not. This panel ruled against California's open carry ban in counties over 200,000 people, but the case was still heading through more process, and the state made clear it planned to keep fighting. That means you need to stay calm, stay informed, and stay disciplined. Also, do not make the mistake of thinking this ruling erased every carry limit in California. It did not. Sensitive place rules, permit issues, local enforcement realities, and future court action can all still affect what happens next. Most people want a simple yes or no answer. Real gun law almost never works that way. So, here's the bottom line. This was a huge win for the argument that open carry is protected by the Second Amendment. It was a serious blow to California's broad ban in the state's most populated counties, but it was not a magic switch that instantly made open carry safe or lawful for everyone that same day. If you want straight answers without the panic, the politics, or the fake legal experts, subscribe right now and stay with this channel. I do the heavy research so you do not have to, and that can make the difference between confidence and a criminal charge. And one final simple disclaimer: laws change, facts matter, and your exact situation may be different. So, talk to a real attorney before you act on any of this.